Do something. Okay, so Federalist Society. We exist to promote 3 principles: that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is and not what it should be. The Federalist Society takes no position on legal or policy issues and does not engage in political advocacy beyond these 3 principles. Professor Blackman let me know last time that Professor Kelso Comments don't need introduction. You guys know who they are. But Ilya Shapiro is a senior fellow in constitutional studies at the Cato Institute, and he is editor-in-chief of the Cato Supreme Court Review. Before joining the Cato Institute, he was a special assistant advisor to a multinational force in Iraq on rule of law issues. Shapiro is the co-author of Religious Liberties for Corporations, Hobby Lobby, and the Affordable Care Act, and Constitution. He has contributed to a variety of academic, popular, and professional publications, and he regularly provides commentary for various media outlets, including CNN, Fox News, ABC, CBS, NBC, Univision, Telemundo, The Colbert Report, and NPR. So some fake news, some news. Shapiro has testified before Congress and state legislatures, and as coordinator of Cato's Amicus Brief program, he has filed more than 200 friend of the court briefs in the Supreme Court. He's a regular lecturer on behalf of the Federalist Society. In fact, this is the 3rd or 4th year in a row. I think he's been here at South Texas.
More than that.
More than that?
No, I think 1 year I was at the Houston College of Law.
Oh. we don't talk about that anymore. That didn't ever happen. I think we're actually barred from using that word as well.
Well, before entering private practice, Shapiro clerked for Judge E. Grady Jolly at the U.S. Court of Appeals for the 5th Circuit. He holds an AP from Princeton University, an MSc from the London School of Economics, and a JD from the University of Chicago School of Law, where he was also a fellow. So he's kind of a big deal. Please join me in welcoming Ilya Shapiro.
Well, thanks very much. It is great to be back. I'm glad that every year it seems like I don't say something too outrageous to be invited back. And as is typical, I have my boots for our Supreme Court Roundup here.
Yeah. What'd your mother teach you?
And I see that Professor Blackman has his new Alexa set up over there. So Alexa, make sure that whenever Josh makes a bad pun to buzz or something.
Zaps me.
Yeah. Well, this past term was one. We're going to talk about both past term, this term, wrap it all up. This past term was one for legal nerds rather than political junkies. We've sort of gotten used to the Supreme Court every year deciding 3 or 4 of the biggest political controversies in the land, whether it's gay rights or guns or healthcare, immigration, voting rights, you name it, they decide several of these, typically in June every year. Last year, that was not the case. There was a regression to the mean. And that's largely because of Justice Scalia's death in February of last year. And so while his absence didn't really change the outcome of too many cases that term, and the biggest one that it did change, that issue is now back again this term, the Janus case, which we'll touch on about workers' rights versus union power. Where his departure really made an impact was on the cases that the court took. And so both the number and the profile of the cert grants were much lower in that year. That reflected into last year. And so this summer, or immediately after the end of term, everybody was talking much more about the travel ban and wedding vendors and sports betting in New Jersey and cell phone location data, all of these cases that were granted for this term, just this past June. And so when we think about last term, or when we do think about last term, when historians look at it in the future, it won't be about the cases, but about the culmination of the battle for the Scalia seat. And of course, that battle ended in a predictable way. Well, the election was unpredictable, but once the election happened, in a predictable way in the sense that the U.S. Justice, Neil Gorsuch, was confirmed on a party line vote after the Senate got rid of the filibuster for Supreme Court nominees. And of course, that was several years after when the Democrats were in the majority, they got rid of the filibuster for lower court and executive nominees. these developments sound like a big deal, but they were predictable given our political climate, and actually returns the operation of the Senate to what it was before Harry Reid, for the first time ever, started using partisan filibusters in 2003. So now we're back to where we were 15 years ago, and so the key consideration is who has the majority in the Senate. We still might have Merrick Garland-type situations where if the President and the Senate are from opposite parties, you could have a blockade, but if the President and the Senate are aligned, then there's less opportunity for obstruction by the minority in the Senate. Although we still have controversies over the so-called blue slips and other arcane Senate parliamentary procedures with the amount of time spent in debate on a particular nominee. So that's what's being argued now. I have a piece in the Federalist just today that goes into a little bit about this. But really, at a certain point, it doesn't matter which party started it or who started escalating the tensions about judicial nominations. The brinksmanship is a symptom of a much larger problem that began even before Ted Kennedy smeared Robert Bork back in 1987. And that's the Supreme Court's own self-corruption, aiding and abetting the growth of federal and executive power, and indeed having this unlikely mix of living constitutionalists joining with their judicial restraint handmaidens to politicize the law such that judges quail at enforcing the Constitution's structural limits and mostly care about being perceived as being for the quote-unquote little guy. One of the most telling exchanges in Gorsuch's confirmation hearing was when Dianne Feinstein rattled off a list of cases where Gorsuch seemingly ruled against the little guy. And then in response, because he's well prepared, the White House counsel's office knows what it's doing, Gorsuch rattled off a list of cases where he ruled for the little guy. So, I mean, obviously that's not how law is or should be done, but there we go. Given the battle that we saw over Gorsuch, only 3 Democrats, all from states that Trump won bigly, Indiana, West Virginia, voted for him. People will now see the justices in partisan terms. We commentators even try to shy away from calling them liberal and conservative justices because there's lots of different alignments depending on the case. But now, too many people, I think, unfortunately, are going to talk about them as Republican and Democratic justices. It's unavoidable to a certain extent because we've had, in the last couple of decades, a very clear and ever more division between both theories of constitutional and statutory interpretation and the most ideologically coherent parties that we've ever had. That is, we now do have a conservative party and a progressive party, whereas before you have overlap. And now there are no Republicans in Congress who are more liberal than the most conservative Democrats, and that's something different. And so that's why confirmation hearings will continue to be kabuki theater, even as the whole process is tremendously fraught. But who knows? We're sort of living in a populist moment where we could have ideological realignment. Who knows what the parties will look like in 10 or 20 years and what the concomitant judicial selections will look like then. In any case, the court has effectively returned to the status quo from before Scalia's death. In almost all of the 5-4 cases, we can expect Gorsuch to vote like Scalia would have. And that includes in the sort of heterodox cases where it's the left and the right against the middle, or the principled against the pragmatic, like, for example, constitutional criminal procedure. Scalia was known as being a great friend of the criminal defendant in 4th Amendment cases, 6th Amendment confrontation clause, etc. Gorsuch can very much be expected to be that way. But regardless, he is the real deal. Those who hoped for or feared a smooth writing textualist got what they expected. In his very first argument, he asked the question, wouldn't it be a lot easier if we just followed the plain text of the statute, right? And he's continued in that vein. Gorsuch's mentor, Justice White, liked to say that each new justice makes for a new court because there's a different dynamic. And I, for one, welcome the breath of fresh air, constitutional seriousness, and intellectual rigor that Neil Gorsuch is bringing. But still, as I said, we're back to the same ideological dynamic that we've gotten used to with 4 towards the left, 4 towards the right, and 1 human jump ball. But that's in its last hurrah. Whenever Justice Kennedy decides to retire, we didn't receive a telegraph from Salzburg this summer, but who knows, could happen this year. The court will move to the right. And the same goes, obviously, whenever Justice Ginsburg departs. And that would mean that Chief Justice Roberts would be at its center. But by filibustering the relatively anodyne Gorsuch, the Democrats gave away any leverage that they had over that next justice or that next nominee. It's not at all clear that more moderate Republican senators, your Lindsey Graham or Lisa Murkowski or Susan Collins, would have gone along with a nuclear option to replace a Kennedy or a Ginsburg with someone more controversial than Gorsuch. But now they will face that dilemma. And one final note about statistics before I talk about a few cases. This past term actually set a dubious record for the lowest output by the court in history, just 62 decisions after argument. And so the court has been doing a very nice job of essentially putting itself out of business. Probably be a little bit of a bump up this term, but nowhere near the 150 that it was deciding in the 80s or the 120 or so that it was deciding in the 90s. The court reversed or vacated 79% of the cases that it heard. So increasingly, getting the court to take your case isn't just half the battle, it's almost the entire battle. And not surprisingly, Justice Kennedy maintained his typical lead, both in cases overall, I think he was in the majority in 98% of the cases, and in 5-4 decisions where he was in the majority in 6 of the 7. All right, turning to the cases from the term. Start with the most colorful case, Mattal v. Tan. This involved the electronic rock group, the Slants.
Simon came here last year.
Simon came to speak here?
Yeah.
Did he play any music?
His band broke down. The most cliche example ever. They got stuck in Dallas.
Well, I've listened to their music for the first time the afternoon after filing our brief, but I encourage you to do so. So the Slants are an Asian American rock band based in Portland. And they wanted to, they're kind of about social justice, and they wanted to take the ethnic slur back, right? So they called themselves the Slants, which is, you know, an archaic pejorative term for Asians. But the Patent and Trademark Office rejected their attempt to register their name as a trademark, which has serious consequences. It's much harder to defend your trademark in the music industry. Most labels won't sign you if you don't have a trademark in your name. You know, all sorts of problems, even though there is common law of trademarks, unless you get that registered with the federal government, it makes it much more difficult. And the reason why the PTO rejected their trademark was because it was disparaging. There was a provision in the Lanham Act, the federal trademark law, that prevents registration of marks that disparage or show contempt to various categories of people, ethnic groups, etc., etc. And so the Slants fought this all the way up to the Supreme Court. They actually won in the Federal Circuit. This is the one case that the Supreme Court this term ended up affirming the Federal Circuit, which struck down that disparagement provision of the Lanham Act on the ground, first, that this is not government speech. That was the government's biggest argument, that this is, registering a trademark is like a license plate. And the Supreme Court a couple of terms ago ruled that Texas could reject a specialty license plate design that included the Confederate flag. Even if some people might think that a license plate that has the name of the state on it might speak, might be the state's message, nobody would mistake all of these trademarks that we have out there for Uncle Sam's endorsement. I mean, is it really the case that the United States government endorses Coke and Pepsi and all of these slogans, just do it by Nike? That's, is that a U.S. government statement? Or more obscure, presumably less venerable trademarks like take your panties off and capitalism sucks donkey balls, both duly registered trademarks. In fact, if you look at the Washington Redskins brief in this case, and I'll get to the Redskins in a moment, the brief is very good, but they have an appendix of 18 pages of trademarks that have been registered that really are more offensive, more disparaging than the Slants. I mean, every ethnic, racial, gender, sexual orientation is insulted there. And it's not just that they have been registered in the past, there's inconsistency. For example, the word Heb, which some people consider to be kind of a positive slang for Jewish people. Some people consider that to be pejorative. But anyway, there are cases that have allowed registration with that, and some that have rejected it. I think the patent office, the trademark office rejected Republicans are all devils, but they accepted Satan is a Democrat. So I don't know whether that's because of the presidential administration in charge of the PTO at the time, but it illustrates the point that there's inconsistency, that these trademarks aren't necessarily government speech, nobody thinks of them that way, and that there's really no principled way of applying this disparagement clause. I mean, does the judge or the patent examiner supposed to kind of think about things, do a Google search about where it's used disparagingly versus not? It's really and it's odd within the trademark statute, which typically disallows registration for objective measures, like you can't have a geographic indication, you can't use a living person's name or likeness without their consent, you can't have a description of the actual thing. So if you're an Apple company, you can't call yourself Apple. If you're a computer company, you can. That sort of thing. These are all objective measures. This disparagement thing was an outlier. So anyway, the court struck that down unanimously, and I commend to you there were a lot of colorful briefs in this case, including my own, filed on behalf of a basket of deplorable individuals and organizations, including P.G. O'Rourke, Nadine Strawson, former head of the ACLU, Flying Dog Brewing Company in Maryland. In fact, we're the first brief ever.
What's the name of their beer, Ilya?
We're the first brief ever to reproduce a full-color beer label in the brief for the wonderful Belgian-style IPA Raging Bitch. So, there you go. Trinity Lutheran is the other case I wanted to briefly mention. In Missouri, they have a program that will subsidize playground resurfacing. I mean, when I was a kid, if you fell down off the playground, it was just like dirt and rocks and tree branches and whatnot. You broke your arm, you learn from it. But now in today's world, we have to coddle our children. I might feel differently about this. I have an almost 2-year-old, another on the way, so maybe I will enjoy these playgrounds. But anyway, they take these rubber things and they put a playground surface. And so they had these subsidies with all these criteria for determining who can get the subsidy for the playground. Trinity Lutheran Church in Columbia, Missouri applied, qualified, was I think the fifth most qualified applicant, but then a bureaucrat in the state government realized that Trinity Lutheran Church was a church and disqualified them on that ground. And so Trinity Lutheran brought a case based on the Equal Protection Clause and freedom of religion. Ultimately, the Supreme Court ruled for them 7-2, saying that, look, this is not a subsidy for Bibles or pews or anything that foments religious activity. This playground resurfacing, it can only be used for that. It's not just kind of a generic pot of cash. You only get it if you've already spent money on playground resurfacing. Although there was a curious footnote 3, where John Roberts, writing not for a majority but for 4 justices, saying this case involves express discrimination based on religious identity with respect to playground resurfacing. We do not address religious uses of funding or other forms of discrimination. Who knows what that means? Stay tuned. Before moving to next term, I'll just highlight one other case, and this is the Indian law case of Lewis versus Clark. That's all I'll say about that. Unfortunately, there was no intervention by Sacagawea. Moving to this term, Gill versus Whitford, the big partisan gerrymandering case that was heard a couple of weeks ago. This will either be a monumentally huge case in American politics, or it will be absolutely nothing and we'll forget about it, immediately after the case is handed down. So the Supreme Court has never struck down a districting plan based on politicians using too much politics in drawing the districts. Even though there's complaints from political scientists and political activists that, well, whenever one party gets a majority in both state houses and the governor's office, they draw districts that favor them, and since time immemorial. Well, here, this is the facts of this case seem pretty egregious. In 2010, Republicans took complete control of the Wisconsin state government, and even though Wisconsin is pretty much a 50-50 state, the Republicans drew districts, and indeed even before drawing districts, even under the old districts, the reason they won this majority, the way that the things were drawn, that they won something like about 2/3 of the state House and Senate seats, despite only winning about half of the vote. And that's largely due to Democrats being more concentrated, Republicans being more spread out, and this plan exacerbated that even further. But is that a constitutional claim? A couple of retired law professors argued that this partisan gerrymandering disenfranchises people who are packed into these overwhelmingly Democratic districts. And the same thing happens when Democrats run states in other contexts, in Maryland, for example, or certain other states. So, for example, all of the Democratic districts are won, 80-20 or more. All the Republican districts are fairly reliable, but they're more spread out. So you win them 60-40 or something like that. And the difference in that, how comfortably you win those districts or how spread out your votes might be, some academics have called the efficiency gap. What is the difference in the number of wasted votes between the parties? It's a really interesting political science kind of theoretical discussion. Unclear whether the court will constitutionalize it, and as nobody will be surprised, Justice Kennedy is in the middle of it all, as he was the last time the court took up a partisan gerrymandering challenge in 2004, where it split 4-1-4, with Kennedy saying, no, this is not a good challenge, but perhaps in the future there will be some sort of manageable standard. Stay tuned. But the court might not even rule on the merits at all, because there are standing issues. You typically can't challenge an entire map, you have to challenge a district. Also, there are some questions about whether the 3-judge district court applied the previous precedence factors correctly, all this technical stuff. So the court, if it wanted to, can avoid ruling on the merits one way or another. So this is likely to be a fizzle. Finally, Christie versus NCAA, which is kind of like the Iran-Iraq war. You want both sides to lose. It's actually a major federalism case involving sports gambling. 25 years ago, Congress passed the Professional and Amateur Sports Protection Act, which prohibits sports gambling. It carved out certain exceptions, like Nevada can have sports gambling for obvious reasons. Certain other states, Indian casinos, all these things. There was a window of 3 years for New Jersey if they wanted to legalize. They missed that window, but later they decided that they do want to legalize sports gambling. The feds are saying, tough, you missed your window. New Jersey's saying, wait, are you telling our legislature which state laws we can and can't repeal or pass, or which regulations we can enact? And the federal government's saying, no, you just can't pass state laws that conflict with this federal law. So that's where the battle is joined. Is the federal government effectively commandeering state legislators and saying that they can't legalize for state purposes this sort of activity? Or is it, curiously, that they can repeal the state ban, but they can't pass any regulations that could be seen as enabling the gambling that would be in conflict with the federal law? That's bizarre. That would be like, you can have a free-for-all, but you can't have a properly regulated system. But this has ramifications beyond either New Jersey or sports gambling. All of the circumstances that we've seen lately where there's tensions or pushback by the states, blue states or red states, against federal action, whether on marijuana or guns or sanctuary cities, a whole host of areas, depending on how the court decides this case, will have an effect. And finally, just some more kind of broader things as we go into the term. Last term, of course, was the end of the Obama presidency and its performance before the Supreme Court. It set a historic low, at least a modern low, for performance by the Solicitor General's office, winning fewer than 47% of its cases, and losing unanimously 48 times. That's more than 50% more than either Bush or Clinton. And the reason why the Obama Justice Department did so poorly aren't because its lawyers are terrible. They all got better grades than I did and had Supreme Court clerkships and all that, but because the administration saw no limits on federal and especially prosecutorial power and accorded itself the ability to enact a legislative agenda when Congress wouldn't. So President Trump, who so far has gotten off to an even less auspicious beginning, 1-9 at the court with 5 unanimous losses. Now, part of this is artificial. These are not blockbusters where the administration changed sides or anything like this. But anyway, that's the way we count. But if President Trump wants to improve the government's legal record, then I humbly suggest that he follow Cato's lead, who went 8-4 on the term. Very respectable. Advocating positions and advising executive actions that are grounded in law and that reinforce the Constitution's role in securing and protecting our liberty. Before I toss it to Josh, one more note to keep in mind, and that's going back to Gorsuch, and in fact the ceremony where his nomination was presented at the end of January. The then judge mentioned two people who had occupied the seat that he now holds, Justice Scalia, of course, but also Justice Robert Jackson. Jackson is known as one of the best writers the court's ever had. He's also the only person to have been Solicitor General and Attorney General and Justice. He also took some time off to be a Nuremberg prosecutor, definitely a legend in American law. He also, by the way, was the last justice who did not complete law school, so it's not too late for all of you sitting here.
Wrong advice.
But anyway.
Graduate, please, pass the bar.
Well, no, you want the people who wouldn't pass the bar not to drop out, right?
Quit while you're ahead, give it over to me already.
Anyway, Jackson is most famous for two opinions: his concurrence in Youngstown Steel, the 1952 case where the court rejected Harry Truman's attempt to nationalize the steel industry, and that's still the standard, his concurrence, the standard by which executive action is measured in the face of congressional acquiescence, disapproval, or silence, and his dissent in Korematsu, the 1944 case where the court, to its shame, in my view, allowed the wartime internment of Japanese Americans. I think it's no coincidence that the silver-haired nominee name-checked Jackson, and that should hearten those who are dismayed by a politics gone off the rails. When push comes to shove, the elegant Justice Gorsuch will help preserve the Republic.
Is that me now? Well, thank you so much. It's a pleasure to be here in South Texas. This is usually when I travel to schools. I have to get on a plane, but here I just took an elevator. Ilya is a dear friend. My microphone on? Are you pointing at me? What? No. Anyway, so it's a pleasure to be here with Ilya and Professor Kelso, which are both dear friends of mine. I want to talk a little bit about the upcoming term, and in particular, a couple cases that you may have heard of. One of those cases is called the Masterpiece Cake Shop, and this is a case which you're familiar with. You've heard of it before. You have a baker in Colorado. The baker has been serving customers in that area for years, but they have some unique policies. They will not make a cake for things they find morally objectionable. Now, the example you probably heard of is they won't make a cake for a same-sex wedding. They also won't make a cake for Halloween because they consider that devil worshiping. They're pretty consistent in their beliefs, and there's no allegation that these beliefs are not sincere. The Colorado Human Rights Commission has brought enforcement action against them, saying that because they turned away a same-sex couple to make a wedding cake, that they're violating the discrimination law. Now, this case is not about the freedom of religion. In fact, the free exercise clause isn't even implicated. And Colorado does not have a RFRA, I don't think.
What are you talking about? It's one of the claims.
No, this free expression.
Sure, that's what it will be decided on. Well, not that, I mean, that's what I think, but
Yeah.
it's definitely part of the question presented.
They think they should exercise.
It's there. This is why I said I would take this case.
So the case is
primarily, you should talk about your property cases.
Oh. Anyway, so the case here presents the question about.
I actually filed a brief on this.
No,
I can do it if you want.
Okay. So the case here involves primarily free speech. And the question is this: can the government require a baker to make a cake against their wishes? Specifically, is the act of providing a cake for a same-sex wedding an act of free speech? And this implicates a line of cases that stretches back to Justice Jackson, Ilya mentioned earlier. Long before people were taking a knee, people refused to salute the flag while the Pledge of Allegiance was recited. And there was a question involving some Jehovah's Witness children. Could they be required to salute the flag during the pledge? And there was one case where the court ruled, of course they can be forced to do it. The court quickly overruled that decision in a case called West Virginia v. Barnett, written by Justice Robert Jackson. And the court held that if there's any fixed star in our constitutional constellation, It's that people can't be forced to take various positions. Another case involved license plates. Maybe you may know the motto of New Hampshire is a live free or die state, and their license plate says live free or die on it. One guy didn't like that message. He disagreed with it, so he put a piece of tape over his license plate and said, I don't want to endorse that message. And they said, you can't do that. And again, the Supreme Court said, in the case of Willie v. Maynard, that you can't be forced to express a message. Now, those cases are easy, saluting a flag, putting a message in your license plate. This case is a little bit different. No one's asking them to print a book or write a pamphlet about gay marriage. They're simply asking them to bake a cake. Is the act of baking a cake speech? And if so, does the government have the power to require you to do it?
You know, now that I think of it, there's lots of ways to slice this case.
So I think one of the reasons why this case is so difficult is it implicates the Supreme Court's decision in Obergefell v. Hodges, decided a couple of years ago. This is the same-sex marriage decision. And in that decision, Justice Kennedy had this little missive about how people are free to worship as they wish, but he didn't use the word exercise. So because Obergefell sort of revolutionized this field without having much legislation, these are the follow-up subsidiary issues. So the court's going to have to decide, can we carve out an exception to a discrimination law based on the free speech claim? The second big case that I think will eventually come back to the court involves the travel ban. This is a policy that began in President Trump's first week in office. It's gone through several iterations, and in each iteration the lower courts have stopped it, so I will try to grossly summarize it. But in short, these policies attempt to use the president's power, both statutory and constitutional, to deny entry to certain aliens based on their home country. There's not a finding that anyone in particular poses a danger to national security. There's not even a finding that any of these people have connections to terrorism. Merely by virtue of their citizenship, where they're from, they're subject to travel restrictions. And the specifics are far beyond the scope of what I want to talk about. There are 6 or 7 countries on the list now, but the bottom line is this: can the government deny you entry? The lower courts have uniformly ruled against the Trump administration. The Supreme Court has done this weird little dance where they say, well, the Ninth Circuit went too far, we'll give something here, we'll give something there. As things stand now, we're back in the district court. A couple days ago, district courts in Hawaii and in Maryland issued what are called nationwide injunctions, barring the enforcement of this order. The case, I think, will rocket up to the Supreme Court fairly soon, and I expect the justices to take it probably in March or April, right at the end of the term, and we'll get a ruling on it in June. So I think this year, in addition to the political gerrymandering case, as well as the mass cake shop case, and the travel ban case, were the biggest cases of the year. I don't think in any of those, Justice Gorsuch will vote any differently than Justice Scalia. But I'll tell you, he voted for sure differently than would have Justice Garland, who could have been appointed otherwise, or whoever President Clinton could have nominated. But then again, if President Clinton was nominated, we would have a travel ban. So I suppose it's a false hypothetical. I will stop here and let Professor Kelso provide some comments, and maybe I'll answer any questions later. Thank you very much.
Okay, I'll just briefly talk about each of the cases that were sort of mentioned there. First, going back to the Tal v. Tam, the Slants case. The court did, of course, what was sensible to say, well, they ought to get their trademark. That was easy. The real issue is they wrote a very broad opinion, basically saying the government can hardly use any discretion at all, that just because something's offensive, you got to give them a trademark anyway. And the question is going to be, not for the Redskins. Redskins are going to get their trademark under this opinion. That's easy, too. But if groups start trying to sort of really push it and want to get very, very offensive kind of trademarks, will the court say, well, the logic of our Tal v. Tam opinion says the government's got to give them that trademark, too? So whether it's a white supremacist group, a neo-Nazi group, and I want to trademark something, do they now get to have a right to trademark in a way that previously the government would have said, no, that really is going too far. We don't want to have any sort of endorsement in our trademark system with that extreme message. I'm not sure how the court will eventually, will they sort of pull back from some of the broad language in the Tal v. Tam or not? Who knows? We'll see. Again, the Trinity Lutheran case, it was an easy case in terms of just providing funding for, the Roundup tires and rubber for playgrounds. That's easy. Chief Justice Roberts did in footnote 3, he wrote it very narrow. He said, well, this case is just about this particular issue. We're not necessarily changing our doctrine about how much government funding can go to churches. And he did it for 4. I mean, with those 4 plus the 2 dissenters who thought that, well, even in this case, you shouldn't give the money to the church. That's 6 votes really for that case officially being sort of a narrow opinion on the precise facts. But, there's other language outside of footnote 3 in that case that suggests maybe there's a sort of avenue to broaden how much money can go to churches and not violate the Establishment Clause. So again, we'll see down the road sort of if anything comes of that, but at least in that case, the footnote 3, the point of it was to keep this narrow, not to take on broader Establishment Clause issues. Okay, Gil v. Whitford, the case about gerrymandering in Wisconsin. Let's suppose Kennedy joins the 4 liberals and says, yeah, I think Wisconsin went too far here. This is political gerrymandering, and now we do have sort of a manageable standard based on the efficiency gap, that you have totally packed Democrats into a few districts that they win overwhelmingly, but then they lose all the other districts in the state by 60-40, 55-45 margins. And suppose you say that is unconstitutional, that's just too far. Is that going to be a huge big deal? My instinct is no. My instinct is that if Kennedy joins the liberals, it'll be a narrow opinion on they really, really went overboard in Wisconsin with the legislature and Governor Walker. They went way overboard. That one's unconstitutional. It won't, to me, be written in a way that makes gerrymandering in Ohio, or Pennsylvania, or North Carolina, or other states like that, where there is some gerrymandering, clearly unconstitutional necessarily. It'll be a boon for litigation. Lawyers will love it. Now you have challenges of congressional districts drawing in a number of states. But it's not clear to me it will actually change the political dynamic much. Even in Wisconsin, you redraw the districts in a more sensible way. Maybe you get one more Democratic representative in Congress, but probably not much more than that, because a lot of the Democratic votes are just located in Milwaukee and Madison. And so even you draw districts just sort of normal, sort of square or circle districts, you're still going to have Madison and Milwaukee be overwhelmingly Democrat, the rest of the state be 55, 45, 60, 40 Republican anyway. So even in Wisconsin, it might make 1 congressional seat difference. Overall, nationwide, it might make 5 or 6 congressional seats different. And that's, the margin something. But I don't think Gil v. Whitford, no matter what happens, is going to be all that huge.
Except election lawyers will benefit.
Election lawyers, there's a lot of litigation. There's a lot of litigation. And symbolically, it's, do we allow gerrymandering or not? But okay. The gambling case, there's not going to be commandeering. Kennedy's not going to find it commandeering. He's going to say the federal government has the power to regulate something that affects interstate commerce. That challenge is going to lose with the current court. But it might to me, the interesting thing would be, what does Chief Justice Roberts do? Is it a 5-4 case where Kennedy joins the liberals, saying the federal government can regulate and limit what New Jersey can do? Or is it a 6-3 case where Roberts and Kennedy both join the liberals? That to me will be interesting, because looking down the road, if Kennedy retires over the next 3 years, so you get another Gorsuch on the court, and so you've got Scalia and Gorsuch and Alito and then some other vote, then Roberts is in the center, and all of a sudden, maybe the Christie NC is a sort of 10th Amendment, you're intruding on states' rights kind of case. So for this one, this term, I think it's going to be clearly Kennedy's going to join the liberals. The federal government can regulate it. Tell New Jersey they can't do legalized, sports gambling, because the federal government can regulate interstate commerce. But we will see. Master Beat Cake Shop. I think what's interesting in the college here is, I think there is both free exercise and free speech there. But the reality is, if the challengers are going to win, if sort of the bake shop is going to win, I think it is true, they're going to win on the free speech ground. They're not going to win on free exercise.
That's what I meant.
That's really what I think that's the stronger argument. Because the free exercise challenge under Smith, it's just minimum rationality review, unless you can show this law was passed to discriminate against religion, and it's not just a generic anti-discrimination law.
It's more of an equal protection argument, in the sense that, I agree with you that it's going to be on free speech, but the way that they've drawn it is, there wouldn't even be a claim otherwise, but the way that it's been applied, for example, there literally was atheist bakers who would not bake a cake for some fundamentalist Christian event, and it was not enforced against them. So
now, if you could show that it's discriminating against this person's religion and not against other religions, then maybe you get to strict scrutiny from Smith. My instinct is, of course, not going to find that. But that's the way under the free exercise clause for the bakers to win, is to say you're discriminating against my religious beliefs, not other people's beliefs. And then discrimination against my religion, you get to strict scrutiny. But I guess my instinct is that's not going to succeed, so then it's minimum rationality and you lose. But the free speech one, that is interesting. Because can you get the court to think this is, you're basically forcing the baker to endorse a message, or is it just the conduct of selling a cake, either to the gay groups or the people who want cakes for Halloween or whatever? I mean, it's not as obvious a case of saying I don't want to endorse the message as saying I don't want this on my license plate, live free or die. There the person is saying I don't want that on my license plate. I don't want my car driving around. Here it's you're selling a cake to somebody else. They're going to have the cake. Is it really you endorsing the message just by selling them a cake? I'm not sure you can make that a free speech case, but if you can...
You think that theory is half fake, huh?
Yeah, I think that's not going to work myself, but it's close. And Kennedy is big on freedom of speech. If you can get this case over into thinking about it as a free speech case, Kennedy might join the other conservatives and support the baker. And so that to me will be interesting as it goes forward. It's just, I'm not sure that selling a cake really is you're endorsing the message of the buyer. That's an odd kind of thing to say. Okay, finally, Trump travel ban. That's again one of those symbolically of great importance, but practically speaking of almost no relevance at all. Because Trump's going to do what he wants on immigration. In any event, even if you don't have a formal travel ban, you can administratively, on a case-by-case basis, shut down immigration. 95% or what, 98% of what you want anyway. It's not going to make much difference. It's sort of like those cases under the Bush administration involving the detainees at Guantanamo Bay. At the end of the day, Bush's view that he could determine the rules at Guantanamo Bay was viewed unconstitutional by the court. And then when Bush and Congress got together and came up with rules that denied the detainees at Guantanamo Bay any real due process rights, that was ruled unconstitutional by the court, 5-4 with Kennedy joining the liberals. But the reality is, that case, saying that Congress and Bush were denying the constitutional rights, only came about in 2008 at the end of the Bush administration. Almost all the people in Guantanamo, they were dealt with the same way, whether the court had ruled it constitutional or not. And even after that, when Obama was then president, he released most of those people also, and he would release them anyway, without regard to what the court said in terms of the standards of review you need. I mean, the fact is, at one point there were 700 detainees or more at Guantanamo Bay. Bush released a whole bunch of them, got down to like 250 by the time Obama took office, and all those people were released without regard to whether his policy was constitutional. It was unconstitutional policy, but he released them anyway. And then Obama took 252 down to 41. So the fact that the court, it was symbolically important to say the president can't make policy and that Congress has to give these detainees some rights, symbolically, but it didn't affect much of what happened to the detainees at Guantanamo Bay. Same thing, I think, in this Trump travel ban. Most of the immigrants or refugees from these named countries, they're not going to be getting in no matter what, whether the, quote, travel ban is effective or not. But I will say this. The real chance that the Trump administration has on it, so far they've lost even this third one in the lower court. The real chance they have when they get to the Supreme Court is they're going to have to convince the court there is actually a problem here that needs to be solved. And it's not clear there's a problem. It's not clear that the Obama enhanced vetting that was already in place really was a problem. Now, Trump during the campaign, of course, made a big deal. Oh, it's a problem. It's a sieve. People can just come in. We have no idea who's coming in. It was sort of campaign rhetoric. And that's fine for campaign rhetoric. The question is there an actual problem you're trying to solve now to which this is a rational response? Or is it just, I said it during the campaign, and so now I want to put in a ban to show that I'm following up on my campaign rhetoric? If that's all you're doing, if you're just following up on campaign rhetoric with no problem, you're going to lose. And you're going to continue to lose because there's not a problem to solve. And the problem is so much of what Trump does is following up on campaign rhetoric that makes no sense at all. And he pulls out of the Paris Accord. No sensible person thinks that pulling out of the Paris Accord makes sense, but Trump said it during the campaign, so he does it. Now, they're talking about, I still want to build a wall with Mexico. It makes no sense at all. But he's still trying to build. I've got models out there because he's following up on his campaign rhetoric about that. To the extent you've got a bunch of these things where Trump seems to be following up on campaign rhetoric, even though it doesn't really, and I'm not certifying the New Deal with Iran. no what, every other country in the world, and even people at the Department of Defense think that Iran is complying with their obligations enough, we ought to stay in the Iran deal. But Trump said during the campaign, I think this is a horrible deal, it's terrible, I want to pull out of it. So Trump has a history of sort of doing things now that don't make a whole lot of sense rationally, but I'm following up on campaign promises. Because that's what Steve Bannon told him to do, it's what Steve Miller in the administration is telling him to do. You be a different politician, follow up on your campaign promises. Well, if that's how the courts view this travel ban, Trump's going to continue to lose. If he can actually convince the court that there is a real problem here and this is a real response, then he might win. No.
Josh, are campaign promises and tweets subject to a rational basis or strict scrutiny, or how does that work?
So let's talk about Christie for a minute, right? And I think there's actually a related case where you can bridge the two. Bridge. See, there was a case involving some of Christie's aides, and what happened was basically people in the Christie administration wanted to punish some local politicos. It was in Fort Lee, right? In Fort Lee, New Jersey, which is right by the George Washington Bridge, and they basically shut down some lanes on the bridge. Which in Texas, like, what the hell's a bridge? There's no bridges here, right? In New York, when you have Manhattan, it's a very big deal to have bridges, and it creates traffic. And some of Christie's people were actually indicted and charged with crimes. And the defense is, look, this is politics, right? This is how New Jersey works. When local politicos don't vote for our agenda, we punish them. And actually, the people lost them over. I think the Supreme Court will actually reverse this case. Actually, Jacob has a cert petition on this one now. Politics is part of our polity. And I've written elsewhere at long length, I don't think the policy of the travel ban is unconstitutional. I think he has a statutory authority. But if indeed his basis is on keeping campaign promises, I don't think that's irrational. And I think under the standard review, that's enough. Now, they'll make up a reason, right? They'll make up something in court about national security, vetting, whatever else. But as a basic matter, if the president's doing something to keep a campaign promise, that's politics.
I actually don't think there will be a Supreme Court ruling on that at all.
Nope.
It'll be decided, if it's decided, on statutory issues, not on the claims of bias.
We're running a little bit tight.
Yeah, let's get questions. Yeah, you raise your hand.
Is there a precedent of statute authority of the president ever coming under review because of the reasoning of it, where he's actually, in plain English, has the authority under statute?
So if you ask me for other executive branch officials, the answer is yes. But if your question is, has the president ever had an action struck down because of statements he made for this, I think the answer is no. And I've researched this question at length, but Ilya and I wrote several briefs in the US v. Texas litigation over President Obama's deferred action policy. And we were cutting edge. We actually looked at the president's statements about whether this is lawful or not, because President Obama had said for years, I can't do this. And then suddenly when he lost in Congress, oh, I can do this, right? And Ilya and I used this to show that it was not a good faith effort. So now all these people are copying us. But the difficulty in writing this brief, which Ilya and I recognized, is we had no precedent on our side. We were just making it up. I mean, we put together the best we can, but there's nothing.
How do you prove good faith or bad faith?
Yeah, I mean, there wasn't much precedent. But now these district courts take for granted that you can look behind the president's actions, and I think the precedents are not supporting.
Although it's also what's different between the travel ban and US v. Texas, the DACA case, is that the president, historically, the executive branch gets more discretion over foreign affairs than it does over domestic.
It is, and I think my motivating principle in the travel ban case is the president has statutory authority. He also has Article 2 inherent authority to deny entry, and this puts us in Jackson's first tier. And I think it's going to be very tough for the court to strike this. The lower courts can have for fun.
Well, that sort of depends. I would say that the statutory question, there's two statutes. One is the president can deny for national security reasons. The other statute says the president can't apply immigration law to discriminate on grounds of ethnicity or national origin or religion. So the real question is, which statutory provision is this travel ban about? And that's why I said, if you believe there's a real problem, a national security problem, then Trump's in pretty good shape, because then I'm going under statutory authority of national security, that's in the highest tier of Justice Jackson, and I win. If there is no real problem, if it's just campaign rhetoric and I'm now trying to apply it, and what I'm really doing is I'm following up my campaign rhetoric on keep the Muslims out, well then he's violating the statutory authority of no discrimination based on ethnicity, nationality, or religion, And then he's at the lowest tier of Jackson, saying, I'm doing it pursuant to express congressional disapproval, so I don't have inherent authority. And I think he loses on that. Though I agree the court, when they decide it, if they decide against Trump, they'll do it based on, he doesn't have the statutory authority, that he's violating the statute about this is discrimination. It's not really about national security. But again, it all to me depends at the end of the day. Do you believe there's a real national security problem that this is a response to, or not?
How does that factor in though when there's the constitutional authority?
Well, if there is constitutional independent of statute,
Statute.
I don't think there's, it's unclear to me, given that Congress has principal authority over immigration and naturalization under, Article 1.
But is that about one third of the country though? How about getting into the country in the first place?
I think the court is likely to say that Congress has the authority there, not the president. It's not part of inherent executive power. And therefore the president better be acting pursuant to some congressional implied or express approval. And he's got it if it's national security, but he doesn't have it if it's discrimination on ethnicity. And that sort of depends on whether there's a real national security problem. My guess is, but I could be wrong, my guess is that's how the case will come out.
So let's say the Barbary pirates left Somalia back in the day and headed to
That's
the shores.
Barbary, not the Barbary.
Yeah, the Barbary pirates left Somalia back then and headed to New York Harbor. Does anyone think that President Jefferson would need a statute to stop them from entering New York Harbor? I think the answer is no, and that's why I think there's an inherent power here.
Well, but that's a national security issue.
And
my
so-
question, this really isn't. I don't think, that's the question. Is there a national security interest?
I think John Roberts doesn't want to have to take a position on reevaluating national security determination one way or another.
Somalian pirates we. Next question, yes.
Is that because there's a lack of evidence to suggest that these people who are immigrating here aren't a security threat? Or is there other justifications of why this isn't a national security issue?
I think the position here is that the Obama administration on January 20th of 2017 said, we don't need this. And then the second the administration changes, we do need this. The argument is this pretext, right? That the old State Department officials were not stupid. The new ones are just operating under illicit motives. My response to that is it's politics. You have hawks in the office now and not pacifists, right? You have different people, different priorities, and they do things differently. Elections have consequences. And even if all these former State Department officials say one thing, the current ones who actually hold office and were elected and confirmed can say otherwise.
Didn't the Obama administration
Raise your hand.
did the Obama
Yes, you raise your hand.
Sorry, yes sir.
Now you can speak.
Thank you. Did the Obama administration actually execute its own version of the travel ban that
Well, they put a new vetting.
It was a visa waiver program.
Yeah, that's where the original list of countries came from. Any questions on any other cases or other issues?
Okay, so you guys were talking about the cake and not being a form of expression, but frequently cakes have writing on them. If there were writing on the cake, would that make a difference?
That could be a way the court decides it.
So for us, or no for us?
I was actually serious when I said there are different ways to slice the case, because there's the writing, non-writing. There's the artistic, okay, bakers are or are not, yes, we'll say they are. We'll say photographers are, wedding singers, but definitely not, caterers and whoever else, right? So that's one way. Or there's a custom cake versus off the shelf. He said you can take any cake off the shelf or cupcakes or whatever, pastries, but I can't make a custom one because that's me like doing my artisanal work specifically for this event that troubles my conscience or what have you. Then there's like do you have an open for business storefront versus just a contractor? There was a case out in New Mexico with a photographer a few years ago who I don't think had a storefront. You just had to like call a number or reserve online or something like that, and then you made arrangements. Is that different? Having an actual physical location versus being a contractor. There's lots of ways to. It doesn't matter whether there are lots of alternatives. Like I don't know how many bakeries there are in the particular Colorado town, but in Albuquerque there are over 100 wedding photographers, and who knows? She may be the only one who didn't want to work a gay wedding, so maybe that matters. So there's all these different directions that Justice Kennedy will have to bear in mind.
Yeah, but the thing is, it's not, again, even if you're writing a message on it, it's not the baker who's coming up with the message. The couple is coming up with the message, or the person who wants the Halloween cake is coming up with the message. They're just telling the baker, you serve as the conduit to put it on there. But nobody's saying the person doing that business function is endorsing that message. It's not their message. They're not coming up with the message. So to me, it's going to be hard to really say that is the same thing as having something on your car, like driving around with the New Hampshire license.
Well, the leading case on that in this context is actually out of the Kentucky Court of Appeals, which held and was not not accepted by either the Kentucky or the Supreme Court, on a T-shirt printer who did not want to make a T-shirt for a gay pride parade, with the message and all that. And nobody would have claimed that he was, it's his message, but he didn't want to print the message, and he was allowed to refuse that contract.
Or another one, what if an African-American baker was asked to make a cake for a Klan rally with two little guys with hoods on top of the cake? Or, a Nazi walked into a Jewish bakery and said, make me a cake with an oven on it, saying, Arbeit macht Fried, right? Works make freedom. Old German, right? But I did Margaret, Nebraska.
I don't think there's any state statutes that protect neo-Nazis.
Some states have protect political ideology.
They do.
What a number.
Political ideology.
Ready for that, Randy? Don't worry. Other questions? We're a little bit running out of time. Maybe one more question.
Well, do we have to give up the room at some point?
No.
I can keep going.
Yes.
I don't know how to do this. I have a flight to New Orleans tomorrow morning. I have to cut it off there.
We're taking him to Nymphos tonight, so he's going to get some good dinner. No, okay. Yeah, back.
Do you really think any of these cases will make any kind of broad-reaching decisions, or will they all very narrow?
I'm glad you asked this, because we actually haven't talked about the case that won't necessarily make the biggest headlines, but which I think will have the longest term impact, and that's Carpenter versus United States, which involves the potentially warrantless search and seizure of historical cell site data records. That is, all of us walking around with these devices in our pockets and handbags are constantly pinging off cell towers, and that information doesn't just disappear into the ether. It's recorded and stored on servers owned or controlled by our service providers, Verizon, T-Mobile, Sprint, whoever you have. And the police, law enforcement agencies, pursuant to the Stored Communications Act of 1986, can just issue a subpoena saying, we're conducting an investigation, I want to see that information, where you have been for the last 4 months. And under the current law, they're allowed to do that, but should they require a warrant? This raises issues, long-standing doctrine that might need to be reconsidered. That is the reasonable expectation of privacy that should be ingrained in your heads from talking about the Fourth Amendment, which this year actually celebrates its 50th anniversary in the case of Katz versus United States. Does that even work in the digital age? Even if, we all know or reasonably can be expected to know that we're constantly giving off these signals to the cell towers, which is then reported, which not all of us do, but perhaps we should be expected to know. Well, if everybody in society does that, that means we no longer have that aspect of privacy. Is that really right? There could be time for a sea change, like what happened with Katz, which overturned a doctrine from the late 20s that held that, yeah, when you speak on this newfangled device called the telephone, inside your home, the police can't listen in. But sure, that data, that voice signal goes across wires outside, and they can attach alligator clips and listen into you off the telephone towers, because that's not in your home. Well, that old doctrine was overturned by this idea of a reasonable expectation of privacy. Similarly here. But if they're going to reconsider that, they also need to reconsider the third-party doctrine, which is from a 1979 case called Smith versus Maryland, involving pen registers. That is, you're already giving information to your telephone company, AT&T, about which numbers you dial. That's all stored. Therefore, the police don't need a warrant to attach what's called a pen register to get that information about which number, not to listen to your calls, but which numbers you dial. It's sort of akin to the police don't need a warrant to search your garbage that you've left out on the street and discarded for pickup. They can just rifle through that. So if the court is going to reconsider this doctrine about expectation of privacy or what to do about digital data, this data is being held by a third party, your cell phone provider, although you have a contract with that cell phone provider. So is that important? If you've taken not just physical steps of going into a phone booth like in Katz, but here legal, contractual steps to protect your information or data, or perhaps you've taken technological steps or something like that, then maybe the onus is on the government. And in any event here, we're not talking about a real-time GPS tracking. The government has more than enough time and opportunity, if it really does have probable cause to believe you did something, to go get a warrant and then access that information. But that's, long-term for the Fourth Amendment, that may well have lasting consequence.
Questions? Anything else?
Well, I was going to say something to relate to the point that, to me, one of the interesting things in that case, and then others of these Fourth Amendment or Sixth Amendment Confrontation Clause cases, will be whether, of course, it does in fact follow Scalia, who was, sort of, that was, as indicated, joined with some of the liberals to have a little stronger pro-criminal defense rights perspective for different ideological, different interpretive reasons, but still, he joined, so with that majority. Will Gorsuch continue that or not?
Based on his history, he's very likely to be. And here's another difference.
The question is, if that history is to the Court of Appeals. When you get to the Supreme Court, to me, I'm going to be interested to see does Gorsuch.
Here's another area where Gorsuch and Garland would have been different. Garland always defers to the government, especially in law enforcement. Yeah. Former prosecutor. So here, Gorsuch could be expected to be with the liberals. Garland could have been expected to be with the law and order conservatives.
Because when you're on the Supreme Court, you're in the big league. Thank you all so much.
That's huge.